Dr. Bob Smith came to our law firm. He was a hospital physician with 15 years experience. The hospital let go a lot of its staff, and Dr. Bob decided to open a telemedicine practice focusing on functional medicine, emphasizing nutrition, dietary supplements, and lifestyle. Dr. Smith asked us for some basic legal advice on how to structure his functional medicine telemedicine venture. Hi everyone, I'm Michael H. Cohen, founding attorney of the Cohen Healthcare Law Group. We help healthcare industry clients navigate health and wellness, FDA legal issues, and successfully grow their health and wellness product or service. The first issue Dr. Smith faced was the online dispensary. It offered him a 25% profit if he sent patients a link to his portal for the manufacturer for the distribution of dietary supplements he would recommend to his patients. Is this an impermissible conflict of interest? Dr. Smith asked us. The impossible question. Most states prohibit kickbacks, and kickbacks include simply making a profit for sending the patient somewhere. In legal terms, we call this a referral. Typically, we do think of a referral as sending the patient to a practitioner, but in many states like California, the concept of referral is very broad and could include, for example, sending the patient somewhere to buy something, such as, for example, a dietary supplement or cosmetic. Now, whether states actually enforce this rule to the letter in situations involving physicians and online dietary supplement sales and portals is another matter. Let's just say we don't believe a lawyer can give an unqualified green light here. But having said that, Dr. Smith is willing to accept certain enforcement risks, and he has asked for help mitigating his legal and regulatory exposure. Next, Dr. Smith wanted to create a care team consisting of other additional healthcare professionals who would act as subcontractors for his practice. We faced this question before, and the question has been whether you can leverage off the fee of a fellow healthcare professional who serves as a contractor. It does raise kickback issues. Then again, with physicians, this is a common model. Now, as to what happens when Dr. Smith tries the third thing, which is to mix and match practitioners such as a dietitian, a nutritionist, a massage therapist, and a health coach, and a physician, and a psychologist. Again, we can't give Dr. Smith total immunity, but we can say that employment doesn't pose the same anti-kickback and fee splitting concerns, and is recommended in states like California that are tough on the misclassification of independent contractors versus employees. And last, Dr. Smith wanted some assistance with basic corporate drafting such as office policies, telehealth and other consent forms, disclaimers for social media, website educational videos, newsletter and online platforms, privacy policy, terms of use, and an MSO agreement. Well, once we straightened out Dr. Smith's regulatory questions, we turned next to the agreements. Dr. Smith survived getting fired by the hospital. In fact, it was a divine boon. It was the best thing that ever happened, as his telehealth functional medicine practice took off. Thanks for watching. It's a pleasure to work with people like you. If you still have questions, please click on the link below, cohenhealthcarelaw.com/contact to send us a message or book an appointment. Here's to the success of your healthcare venture. We look forward to speaking with you soon.